Does it matter that the house isn't in my name in divorce? Hi, I'm Bill Farias, founder and CEO of Farias Family Law. We are a Massachusetts divorce and custody firm. And the answer to this question is no. It does not matter whose name the house is in. And that's because in Massachusetts, all property owned by either party, jointly or individually, is considered for division. Now, that doesn't mean that it's actually going to be divided. It just means everything's in play. The most important aspect of this is that there are factors that the court has to look to in deciding what property to divide and how it will be divided. And really, the most important factors in my experience have been the length of the marriage. The longer the marriage, the more likely it is that the asset will be divided. The contributions of the parties, this one's really important. And the shorter the marriage, the more likely it is that the specific contributions will weigh more heavily. And what's important to understand here is that this isn't an all or nothing proposition, in the sense that it doesn't mean that if the property is or the asset is in the pot, that it's going to be divided 50-50. It could very well be a very different percentage. Like, you could have a judge order that one party keeps 75% of the equity in the home and the other party keeps only 25%. The important thing is that you want to figure out sooner rather than later, by talking to an attorney, how a judge is likely to evaluate this issue so that you can start planning accordingly. You need to know whether all of the equity is likely to be in, only some of it, because then you have the info that you need to start thinking about whether a buyout makes sense, where one party buys out the other party and keeps the house, or if instead the house needs to be sold. So does it matter that the house is not in your name? No, it does not matter. All property is considered for division. The judge has to look at the factors, including but not limited to length of the marriage and contributions of the parties, and know that just because a house is being considered for division doesn't mean that it's going to be a 50-50 split on the equity. It can be anything from one party keeping all of the equity to a 50-50 split, anything in between. If you have any other questions about this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this helpful, you can subscribe, like, share, and you can find us on social media at Farias Family Law. Thank you. Have a good day.